All right, guys. So we're going to cover surveys. So I know it's something that sounds very simple. Everyone knows what a survey is. I get a lot of questions. What needs to be on the survey? What kind of survey do you guys want? Surprisingly, there are different types of surveys out there. And more times than not, we actually do get the wrong ones sent to us. There's boundary surveys, there's demographic surveys, elevation certifications. There's different ones out there. I'm going to go over what title looks at, what lenders look at. It has to have the right information on there. Anything that's missing, and we're going to go over. I mean, literally, we have like a checklist, so we're going to go over what needs to be on the survey. And I should have a handout that kind of goes over what we're going to talk about. And then that handout that you have is actually part of this little webinar, so we're going to break it down a little over together. The thing we're going to start with is title commitments. In order for us to talk about surveys, we got to talk about the title commitment and what the title commitment is going to cover. What it actually is that we're doing for claims, for your buyers, and for the sellers. When we review the survey, it goes hand in hand with the title commitment. Okay? So just in general, before we dive into the survey, what is a title commitment? You guys need to know what that is before we touch on surveys. A title commitment is a snapshot showing the condition of the title parcel of property at a specific moment in time. Once issued, the commitment is good for 90 days from its issuance and obligates the title company to issue a policy of title insurance when all purity requirements specified in the commitment have been satisfied. So when we give you guys the title commitments, I always tell you, if you've been through my classes before, it goes straight to Schedule C. So, and we're going to break it down, but a title commitment has Schedule A, it has Schedule B, it has Schedule D. Schedule C is the skeletons in the deposit section that has divorces and heirships, tax liens, judgments, mortgages. Schedule C is the main one that you guys want to take a look at when you get a title commitment. And then he goes on to say, however, the title commitment can and will update the commitment to show any matters that arise after the date of the commitment and before the date of closing. If it doesn't happen to you, it is rare, but it does happen. Where I'll bounce back and like a week or on and say, hey, guess what? I just will lien on title. It just popped up. And then I'll have an agent ask me, well, how come you didn't see that lien? If something gets filed, the date of the commitment forward, we're gonna run it again. We're always gonna check that property right before closing just to make sure nothing got filed. So it's only good for 90 days. If it's past 90 days, we're gonna get a brand new one. Lenders will ask for a brand new title commitment. But from the date that we first give you that title commitment to the closing, we're constantly running updates on that title commitment. There could have been a contractor who did work, foundation work, and he filed a lien without you knowing. It's going to pop up and we're going to see. So I always get pushback from agents and sellers. How come you didn't tell me this a couple of weeks ago? Well, the lien just got filed. We only see public record. That's the only thing we can see. So if a contractor does work, he has the lien, I can't see it until he files it with the public record. And then we'll run an update and we get notified. So title commitment, what does the title commitment obligate the title company to insure? The title commitment obligates the title company to insure indefeasible title, not marketable title, subject to the conditions specified in the commitment. Indefeasible means that title cannot be defeated, set aside, or made valid. The title commitment and subsequent policy, remember, we give you a title commitment. This is during the transaction. And then at the end, post-closing, that's all said and done, then we issue a final policy. So the title commitment is our commitment telling you this is what's ultimately going to be on the final policy. Let's see, title commitment and the subsequent policy is a contract, not an opinion of title, which means the title company can decide whether a title defect is an insurable risk or not. You'll hear that from time to time, risk, when we talk about surveys. So if you've ever sent me a survey, I'll say, no, that shed that you have in the backyard, draw it on the survey. Because I'm going to give it to the underwriter, and they're going to tell me about the risk involved. And if you don't know that, you can draw on survey. Don't draw on the original, but just draw on a copy. If it's a shed in the background, if it's even an in-ground pool, and it's not on the original survey, draw it in on the survey, send it to me with all the dimensions on it or the title company, and we're going to take a look at it. Why? We're going to look at the risk. Is that in-ground pool 2 feet from easement? We're probably going to need a new survey. If it's really far from it, we're probably going to approve it. We always look at risk. Whether it's a title commitment, whether it's a survey, it's all going to come down to risk. We're an insurance company. It comes down to risk. The contract ensures payment to the insured for a loss incurred. Now, the insured will be the buyer. Ensure the payment to the insured for the loss incurred due to covered title risk, as well as associated costs, i.e., attorney fees, costs, and expenses. This, in a nutshell, is what a title commitment can do. It becomes a policy. We insure the buyer and they're protected. What is the composition of a title company, or I'm sorry, title commitment? I mentioned it earlier. It's 4 different parts. Title commitment is made up of 4 schedules: A, B, C, D. A is kind of an overview of the transaction: loan amount, sales price, who we see as the owners of the property, the new buyers that are involved. It's kind of like a screenshot of the order that is taking place on day 1. You give me the contract, we open it up. That's what Schedule A is. Schedule B is exceptions, stuff that's not covered in the policy. So when you get a title commitment, this is big for like West Texas and East Texas when you're dealing with minerals and royalties. Insurance companies don't cover that. So if you're dealing with a property and it may have minerals, it may be excluded in the title commitment. It may be in Schedule B. Schedule B is everything that's not insured: easements, encroachments on surveys. It's over the boundary line. There's mineral rights. There's royalties. There's HOA restrictions, declarations. Schedule B is excluded from policy. Okay. Schedule C, talked about it earlier. It's all skeletons in the policy. Everything you want to know what's going on the property: death, divorce, judgment, claims, airships, everything that has to be cured or cleaned or taken care of before closing. That's Schedule C. So even here on the buying side, and I've told agents before, even if you're a buyer agent, you get a title for them, don't just think that's the seller's stuff. They got to take care of it. It's Schedule C, because if you got 31 different liens on there, we're probably not going to close on time. If we have a bunch of dead people, we're probably not going to close on time. So just because you're on the buying side, take a look at Schedule C. This may delay closing. You want to talk to the escrow officer, you want to talk to the seller's agent, and see, are we going to stay on track? Or are we going to get this closed? Schedule D, I don't ever go over Schedule D. It's directors, it's shareholders of the company, it's officers. It just has to be disclosed on these. But that's what Schedule D is everybody who's associated with the company. That's that question, but what should I pay attention to when the commitment is delivered to my client? I talked about it earlier. Schedule A, B, and C. Schedule A, compare the name of the owner to the seller on the contract. With Schedule A, we'll have the vesting owner. You'll see you're dealing with the son or the daughter because mom and dad passed away. Schedule A is going to show mom and dad. Not going to show son and daughter. If their will wasn't probated, if their heirship wasn't filed up for record, it's going to show the original last owner. So in that situation, you're dealing with Junior, the son. It may not match what's on Schedule A because you know there's a death involved. If there is no death and there is no divorce, and you take a look at Schedule A, and it's not the seller that you've been dealing with, now you have a problem. Okay, so always take a look at the title commitment and go over it. Compare the name of the owner to the seller of the contract. Make sure the amount of insurance is equal to the purchase price on the contract. That means whatever the sales price is on Schedule A, which is on the contract, that's what we're going to insure. If you have a $250,000 sales, we're not going to insure it for $1 million. We're going to insure it for $250,000. So just make sure those numbers add up to what's on the contract. Your client is protected. Schedule B, make sure your client is aware, and I do get this often, make sure the client is aware of all the exceptions reflected. Certain exceptions are already agreed to by your client under paragraph 6, we'll talk about that, of the contract. So again, Schedule B is everything not included as part of the policy. Make sure the buyer is aware of it. Minerals, royalties, if the house is encroaching on an easement or a setback or the boundary line, we're going to take exception to that. They're not covered. And Schedule C, review the matter that must be satisfied before it goes. What other matters should I be aware of in the commitment? In addition to the exceptions in the title commitment and policy, there are also exclusions. These exclusions are set out and the printed jacket to the commitment is part of the commitment. The exclusions are matters that the title policy does not insure, such as use. Also, if there is a title matter undisclosed to the title company and one that cannot otherwise be discovered by diligent search of the title, but said matter is known to the insured, then that matter is not insured by the policy. Let's say there is a lien out there that we are not aware of, but the seller is aware of it because we're going to sign up on a tax disclosure at closing. It may not be covered. Okay? Because there's a lien out there. And again, it's not filed of record. Not filed of record, it's going to be excluded. We only look at public records. So this is the type of situation where the seller is not being truthful and they're withholding information. They did work on their property. The contractors did work on the property. The foundation was roof repair. So they want roof repair. Those technically don't become filed of record liens. Like a roof repair won't get filed of record if that invoice will come to me. Okay, maybe they did work, they patched something, and they just didn't tell you. We don't know it. There's no way for us to cover that and insure it. They're withholding information. So at closing, I have an affidavit of debts and liens for it. They're going to fill, and they're going to attest to the information. And I ask them, do you have any contractors? Are you going through litigation, lawsuit, bankruptcy, foreclosures, any mortgages that we don't know about? And they have to attest to the information. And if they lie, that's on them. But it will be excluded from the policy.
So what happens if they lie all the way through closing, we close, and then the new buyer comes up, 6 months later and says, hey, I've got this guy knocking on my door, says that we owe him or he has a lien on our property. What happens?
If he attests, the seller attested to that information, now you can sue the seller. He attested and he lied to the information. He lied to the information.
So the buyer would sell.
It's not part of the policy. We don't know about it. It's not public record.
Yeah.
Now, I've had sellers where they're like, oh, yeah, I have so-and-so, he did work on the property. And they put it on my affidavit of debts and liens. I stopped the closing, we're not. Now I need that paid or release it. So it's totally up to the seller. They're attesting to that information. And if they lie, they can end up in court.
Okay.
Yeah.
Exclusions and some exceptions are automatic and may not be objected to by the buyer unless specifically addressed in the contract under paragraph 6. We're going to cover this. It has to do with survey. All right. Appointment checklist. Now, this is a default checklist that's on the PowerPoint. You guys have our actual checklist. So if you've plugged with me before, you've probably seen this. This is called a seller form. I send it out every single transaction. Sometimes we'll send them out for a refinance. But 99% of the time, it goes to the seller every single time. That seller information sheet is everything that we need to know about the seller. Personal information, date of birth, security numbers, marital history. Marital history is a big one. Texas is a homestead state. We need to know marital status. So make sure you have your checklist for your seller information sheet ready to go at your listing appointment. Then you sit down with your client. So that I have one agent. As soon as he sits down, he sends it. I don't even have the order open. He just gives me the seller form. They already filled it out. Here you go. Okay, so I'll just hold it on my desktop until I get the actual file. But he makes sure that he gets that information because part of that seller form is mortgage authorization. I can't order the seller's mortgage until they give me authorization. You got to fill them out. Just make sure you have that information ready to go at the listing appointment because all that is information that we're going to ask. What is a survey? You find a drawing made on the ground by a licensed surveyor showing the results of measuring the land and all factors influencing and affecting the location of improvements, boundaries, right-of-ways, and easement within or immediately surrounding a subdivision lot or tract of land. This is different from a plat. If you've ever heard of what a plat is more general of the subdivision. When a developer develops the land, they create the subdivision and they do the lots, right? They do the lot and lot. So what a plat is, and I should have brought a copy, what a plat is basically a whole bunch of boxes. Instead of a survey being specifically to your property, a plat is the whole entire subdivision. It's like 50 to 70 to 100 different little lots. Very general, very vague, just to show you the setback lines and easements of the subdivision. And that is it. It is not personal to your property. That's what a plat is.
And how about the utilities?
Like the utility easement are going to be on the plat. That'll be on the survey. Oh, 100% be on the survey.
Yeah, on the survey I saw it.
On the plat, it'll be like a 12-foot easement running through all of the lots. And you'll see like a dotted line running through all of the lots. And I should have bought a copy, but it literally just looks like a whole bunch of lots. There's 100 different boxes. and then you'll see the dotted line running through all. So they show the very, very basic, the setback and the easement, and that is it. Now, the easement at the time of development, if they've added more easements since then, it's not going to be on the plat, it's going to be on the survey. The survey is very important. It's precise and personal to the property. Why and when do we need surveys? Title endorsements relating to issuing survey matters. An endorsement is added coverage to the policy. If there's a lender involved, they want added endorsement. There's specific endorsements that a lender wants, and some of those endorsements require a new survey or require an acceptable survey. Not an insured, but an acceptable survey, an insured survey. That's what an endorsement will do. And the endorsement is part of the contract, and we're going to go over that, the survey coverage that the buyer gets. But title endorsements relating to insuring survey matters. It will require a survey. Lender requirements. Legal description is not known or adequate or not adequate for insurance. That's a big one when you're talking about acreage. Lot and block, very general. Lot 1, block 2, so forth. Acreage, and I'm not talking about it, it can be a whole page, not a paragraph, a whole page of the legal description. So your normal legal description that you will see like on a deed, 3 sentences, it's lot 1, block 2, NCD, blah, 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 island, park, subdivision, blah, 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 blah. Bear County, all that. That's it. Low paragraph. Acreage, really the whole page. All right. I know we'll talk about degrees, and we're going to talk about it. Degrees, South Point, West 65. I mean, it's a long page. It can be multiple pages. You're dealing with commercial, it can be multiple pages. So if it's not adequate for insuring purposes, we may require a survey. So even if you put on the contract, I don't want a new survey. If it's acreage, we're probably going to need this. It also is required for access to and from the property if it cannot be determined. Access to and access from. You might have heard it be called ingress, egress. A way in, a way out. All properties need it. And we need to look at the survey, review the survey to make sure there's a way in, there's a way in. Inspection of the property, surveyors versus title companies. Title companies will, from time to time, very rare, inspect the property. That's different from a surveyor going out. We'll inspect the property for if there's like a tenant situation. We want to make sure there's no squatters. We do have investors every now and then. There's specific language on the policy that they want in regards to squatters. So right off the bat, we don't insure anything that has to do with inspecting the property. So there may be squatters in there. That's not part of our title insurance. We'll have investors come in and say, no, I want that coverage. Well, I'll say, okay, I'm going to charge you $400, and I'll go and I'll walk the property and make sure it's there. That's a title company inspecting the property. Different from a surveyor. Identify matters not in the real property records, such as an easement or a setback that's not recorded. That's why you need a survey. It'll still information on. This little paragraph on the right-hand side, it's kind of like the old school meets and bounds. So when you're talking about acreage, and I said the whole entire page, that would be meets and bounds. The legal description is called meets and bounds. Okay. Old school, go in a westerly direction for the amount of time it takes to smoke 2 cigarettes or write a medium, gated horse. In early text and description that we know today as meets and bounds. Old school meets and bounds, I still come across, it'll say some funky stuff. 65 feet to the tree on the right hand side. And then here into the shed. And, is that stuff still there? 100 years. That tree's still there?
Yeah.
Those items kind of little pins. The idea behind meets and bounds is to use a physical landmarks to identify the extent of one's property, 155 feet to a large oak tree, northwesternly 102 feet to a large boulder, and so forth. You can quickly see that if the oak tree blows down, you're in trouble. Modern meets and bounds description is compass points and steel markers or monuments and are precise to 100th of an inch. Not so susceptible to Mother Nature. So the surveyor goes out and puts the giant pins straight into the ground of all the corners. Usually it stays there forever until you personally need it. How to read a property survey. So they're right in front of you guys. We're going to break it down. How does what an actual survey should look like? It should have all that information that is on there.
You have more copies of those? It's not, she took it for her. Well,
Should we some extra?
she took all. We got fun. I need a copy. Get two. Need one.
I'm gonna try to zoom. Let's do there. So, survey should have all the pretty stuff on there. It should have the surveyor's name, the information certificate in regards to the surveyor. So you'll have a stamp, old school. It might be like an embossed print into the piece of paper. So your client will give it to you. You'll see the stamp on there, and then you'll scan it to me, and it's gone. I can't see it. Well, it's embossed. Now you say, I can't see anything. Take a pencil and do a little shading on that so I can see that seal. On your end, you may see it. On my end, I don't. And if I don't see it, I'm going to reject it. It's got to have that seal. It's got to have right underneath it. That's kind of blurry, but there's a little number. It's called an RPLS number. It's got to have that. That's basically the number for the surveyor. Any notes? It's got to have some notes if there's any. The scale, property information, which is the legal description. Boundary lines, of course. Most important is the boundary lines. The compass and the legend. So it's detailed. It's an overview of everything that should be on there. From time to time, I'll get a survey. It's sent to me like that. And I'm going to reject it. I need to see the entire, so where's the seal? Can't see it. Where's the signature? Can't see it. I don't think this one has a signature because it's just a dummy. It's just a sample. But every survey should have a signature on it.
Yeah.
And if it doesn't, I'm going to reject it. That would be like right in the middle. Yeah. So take there, sign there. I think it says approved. So signature there. And if I can't see the signature, I'm not going to approve it. If it's really blurry like this one, I'm not going to approve it.
Yeah, I'll do.
Okay. Just make sure it has all that information. Missing anything. I can't see the little RPLS number, I'm going to reject it. Okay. It's got to have everything that's on there.
That'll work.
Yeah.
Survey requirements. Signature by registered professional land surveyor or registered professional engineer. Date. Seal. Talk about it. Scale. Correction errors. And certification. This is a little paragraph right above the date and signature. Verification that the survey was made on the ground with pins set or found, but there are no visible easements, encroachments, or protrusions except as shows.
Ricky, is there a time limitation on these surveys? No.
I used to get agents say like, "Oh, it's for 20 years. It's not going to be." And the oldest one I've approved is like 55 years old. Well, nothing's changed. If nothing's changed on it, I'll go on Google Images. I'm going to take a look at your listings online. I'm going to look at the pictures in the backyard. We're going to do our homework. We're going to make sure the information that the seller is giving us matches. And if it's exactly the same,
You think that'll work?
I think it'll work. It's got the seal, it's got everything. Number 2, legal description. It's got to have the legal description on it. Okay, if it's missing information, so that legal description, little paragraph, not one block 2, it could be missing something. It could be missing just one word out of it, and it doesn't match the vesting deed. We're going to bounce it back to the surveyor. We'll bounce it back to the seller, and we'll say, guys, have the surveyor corrected. It's a typo. Have them put the information on there. Okay, legal description of the land should match the commitment and closing documents. Number 3, pictorial drawing of boundaries with monuments, established means, natural, whether it's rivers, trees, rocks, mounds, artificial, if there's iron rods or fences. So on a survey, you might see at all 4 points, and I have a little word that says pin, pound, or pin. That's because of the metal rod that's in there. Could have courses and calls such as degrees, north 81 by 18 feet, 50, so forth, so forth. You'll see more of the degrees in the course calls on that long meets and bounds legal description for acreage. Distance, we have the distance also listed as well. The footage. A lot of times you see them like on the boundary line, they'll say maybe like 100 feet right here on the west side of the property, 50 feet here, it'll have it on there. And if it doesn't, we'll bounce it back to you or the surveyor. It's brand new. Tell them to correct it. Location of improvements, such as the house, makes sense, a garage or shed, a driveway. Easements, absolutely 100%. I need to see that on there. Location and width. Property line issues, such as a fence that's over the boundary line, or it's inside the boundary line, which isn't too big of a deal. But over the boundary line, you got an issue. Roadways, location, and whether it's private or public. Building setback lines and utility lines, again, the location and the distance. And when I say distance, I mean like how far from the house or how far from the boundary line. You'll see it on the survey and it'll say like utility easement in the backyard and they'll say 20 feet. That's 20 feet from the back fence or 20 feet from the boundary line that's in the back. Location, distance. If no improvements, it must state it in the certification. Number 5 is measurements showing extent of encroachment and protrusions. Access or lack of access to a dedicated public road or right-of-way public road. Showing adjoining roads, including name and width. Notation of any boundary discrepancies, such as gaps or overlaps. Even if it's on there and that was discrepancy feed, I'll have it sometimes where it'll be the fence and it's like maybe just half a foot off the boundary line. Really good surveys will have that on there and it'll show half a feet. And it'll say, protruding or overlapping or on the neighbors, and it'll say something. Very, very detailed. Number 8, notes regarding any easements evidence by a recorded document provided to the survey. Usually you'll see that on the survey. It'll talk about the easements. Those easements are also drawn onto the survey. If it mentions location cannot be determined, no evidence on the ground, does it affect the property? Is it a blanket easement? I want information in regards to that easement. So it has that information on it. And it gives you the document page of all the documents that are recorded pertaining to that easement. Survey exception. The benefits of the amendment to the survey exception. The amendment to the survey exception in the owner's policy of title insurance provides coverage as to matters not revealed on the survey nor accepted to the residential owner's policy. On the right-hand side, the gray box, the very first sentence, that in a nutshell is what that survey coverage of the contract does. You're amending the policy. The amendment to the survey exception in the owner's policy of the title insurance provides coverage as to matters not revealed on the survey. This is that main question that I get from agents. So what is survey coverage? What do they pay? What does the buyer pay for that added? It provides coverage as to matters not revealed on the survey. If it's missing from the survey, we're going to jump in. We got your back. We're going to investigate. We'll pay out a claim if we need to.
And what's the price on that for the buyer?
The price is 5% of the policy. And again, I'll talk about it too, but it's 5% of the owner's policy, which really not that much, considering they're getting peace of mind and extra coverage to your title insurance. It's really not that much. Now, if you're talking commercial, you're over $1 million, and yes, you can be a little pricey. But more times than not, under $200.
Okay.
Understanding the survey exceptions, examples of the coverage and benefits of the survey amendment when the survey fails to reveal existing encroachments, protrusions, or possible boundary line disputes. It covers in payments of loss in accordance with the terms of the policy arising out of claims to the insured buyer land because of fence encroachments, disputes with adjoining landowners over location and boundary lines, forced removal of improvements because of overlapping improvements, such as a fence or a driveway, encroachments of improvements into an easement or a building setback line, and a utility company or city requires the removal. This is where we'll jump in. This is where we have that. You get your survey, you got survey coverage, you pay for it. Now we're going to jump in and we're going to take a look at it. Who's at fault? What claims are going to be paid out? If it didn't have the survey coverage, we don't care what happened. We won't even review the survey unless a lender is involved. If you have a cash deal and you checked off on the contract and you do not want it, right here on that paragraph, let me just zoom in on that one. So section C, A, it's always that one little marker down there. 2 little boxes. If it says will not, we're not jumping in. You don't got the coverage. We're not taking a look at the survey. I don't care about the survey unless there's a lender involved. So cash deal, if you put will not, cool, don't give me a survey. You also give me a survey. I have agents that give me a survey on a cash deal and there is no survey coverage. Okay, thank you. Just file it away in my file. That's it. I don't review it. Will be amended. Those words right there, why it says amended, every title policy that gets issued has a default language that basically says will not be covered. Your survey coverage will not be covered. That's on every single one that we issue. That second box is telling me, I want you to amend your policy and I want you to add that survey coverage. That's right, there's amend. Amend your policy. And it's negotiable, buyer or seller. Even if the seller doesn't want to pay for it, it's your buyer to pay for it. It's added coverage, peace of mind. Okay. Any questions so far on that one? That's good. And the next one is just zoomed in on it. It's just zoomed in. It's 5% of the policy. For commercial, 15% of the policy. Or if the buyer is an entity, they're a company, they're a corporation, they're an LLC, they're not an individual, it's 15% of the policy. If they're an individual, 5%. If it's land and they're an individual, this is residential coverage. If it's land, it's not your residence. You can't let it. It's going to be 15%. Okay. So land only, buyer is an entity, buyer is, company, corporation, or if it's commercial, 15%. Residential, they're an individual, your standard normal transaction, 90% of the time, it's going to be 5%. Really cheap. Like I said, $100. Worth it.
Yeah, I know.
And then the survey portion, that's always the one that always trips up people. Trips up agents sometimes. I've had agents pay out of pocket because of these three little boxes. If you've been in my title company class, my title 2.0 class, I talk about this and I hammer this into you guys' head. That this can cost you money if you get the information wrong. That very first paragraph. So the other ones are self-explanatory. 2 and 3, buyer's going to pay for a survey. Number 3, seller's going to pay for it. No ifs, ands, or buts, that's it. The one that trips up people is number 1. The reason why, and I should have put a bold print on this one, but situation is you check off number 1. Let's say you're the seller's agent. You check off number 1.
Yeah.
You put 7 days or whatever on that. Then you check off buyer's expense at the bottom. And then time goes on, and you don't ever give me a survey. And I ask for a survey. Was the survey for the T47? No. This has happened. This is 2 agents that I paid out of pocket. No. I checked off the buyer's expense. Number 1, buyer's expense. Within so many days after the effective date of the contract, seller shall furnish to buyer and title company seller's existing survey and T47. Buyer shall obtain a new survey at seller's expense no later than 3 days prior to the closing date if the seller fails to furnish within the time prescribed. You got to give me a survey. You did.
Yeah.
Automatic survey. Doesn't matter if you checked off buyer's expense. That buyer's expense kicks in, the sentence is right above it, if the title company or buyer's vendor does not accept the survey, not accept the existing survey. You got to give me the survey. I got to review it. I'll approve it or decline. And one of those options is going to trigger those 2 boxes at the bottom. But you got to give me a survey first. The 2 agents, they thought they checked out buyer's expense and they paid out of pocket for writing survey. Because it was on them.
On the seller or on the buyer?
On the seller.
Okay, but this will come from the buyer. This form comes from the buyer and they fill it in, or the buyer's.
This is from the contract. So how you guys negotiate those 3 boxes? This is the survey section of the contract, section 6. So it really does depend on your negotiation. Now, if you have the buyer pay for it, then you can just outright do number 3, which is number 2, which is the buyer. But really not necessarily just the buyer filling out, it's how you negotiate.
But it's initiated by the buyer's agent.
Right.
Okay.
Yeah.
So the buyer's agent would check number 1 and say within 7 days, the seller's going to provide a survey, and if not, the seller will pay for a new survey.
And you can check off, if you're on the buying side, you can check off that box too.
Seller buys.
Because that one will come into effect if they give me an existing survey and I reject it. That's still a seller choice.
Right.
So the key is the existing survey.
Existing survey.
Yes.
And if
If
there's
it's one,
if there is no survey,
if there is no survey, it's automatic it's a seller charge. So
so
number 1 always comes down to existing survey.
Yeah,
Always comes down to
yeah. Or you have to choose the second.
the second buyer. All right. That one covered. Understanding survey exceptions, making sense of the survey deletion amendment. Talked about that earlier. To the owner's policy. Remember, Schedule B items of the title commitment are exceptions from coverage. The survey exception reads as follows. Remember, I told you this is every single policy that goes out, every single title commitment that comes out, we automatically do not cover survey issues. This is what it says. Any discrepancies, conflicts, or shortages in area or boundary lines, or any encroachments or protrusions, or any overlapping of improvements. That's what we put on every single commitment. If your customer wants any type of coverage for their survey, they must purchase a survey deletion amendment to the owner policy. The survey deletion is those little boxes. Will be amended? Will not be amended.
Okay.
$2. Okay. And this is issued as a fee equal to 5% of the policy. Let's try to find tomorrow. You might hear T1R residential, T1R residential, or 50% of an owner policy vacant land or commercial. Then it's a T1. That's just a little insight of insurance. You hear it. T1R, T1 residential. T1, there's no residential out. Okay. The additional coverage from this amendment is good for as long as the customer remains the owner of the property. It amends the exception to read as follows: shortages in area. That's it. Whereas the one in the middle right there, that's on every single policy. But if they pay for it, then you get that shortages in area changes, amending the policy. This means that the owner of title policy does now offer indemnity and additional coverage for any discrepancies, conflict, boundaries.
And that's triggered by selecting shortages or whatever in the
Will or will not in contract.
Right.
Will or will not.
actually it's not introduced in closing. Do you want this coverage? It's in the
On the
That's what's triggered.
Survey deletion, which will cover title defects due to surveyor errors in locating boundary lines or improvements, fences or other improvements not located on the boundary line, improvements encroaching onto an easement, protrude over a building setback line, and improvements owned by an adjoining landowner that encroach onto the insured property. I always get agents that say, I don't need it covered. We have a brand new survey. So your surveyors are perfect. So they cannot make mistakes. That's good things. I've gone to every single survey company since I've been doing this many, many years. We've always had some sort of correction from it, whether it's a typo, a clerical error, they miss an easement. I've had surveyors miss easement. My examiners will review the survey and be like, how come they didn't have this easement filed in public record? Where is it? Then they go back and they add it. Why would you trust a surveyor 100%? That's crazy. Get the little coverage. It's a peace of mind. And like I said, it's relatively cheap unless you're dealing with commercial property. 247, not going to go over the one paragraph. You guys know what 247 is. Obviously, going back to that contract part 1, 2, and 3, or the agent pays out of pocket, you got to give me the existing survey and the T47. I've had it where they give me this. I've had buyer agents, and you can do this. If you're obligated to do this, you legally can do this, where the seller, they give me the survey and we approve it. We'll review and approve it with a pending notation that we need the T47. They'll give me the survey, and it's usually TC relative. So I'll get the survey from the selling side. We'll review it. We'll still ask for the T47, but they're working on it. We'll be like 1 day past that date on the contract. So you see it on our brand new survey. We got our brand new survey. Technically, we're past the time frame that's on paragraph 1. They're entitled to the survey. You didn't give me the survey and the T47 within the time prescribed on that paragraph 1. They're entitled to the survey. I mean, I've had agents go out, like really, we're working on it. It's 1 day over. They're entitled to it. It's in the contract. Make sure you get the T47. You can also do the T47.1 if you haven't done it yet. It's awesome. It does not require a notary. Sweet. If you do a T47, it requires a notary. I have agents that come to me, sign T47, saying, hey, can you notarize it? My sellers have already signed off on it. I have to see them. I have to see them sign it in person. And then I'll bounce it back and say, let's see the T47.1. You don't even worry. I'm not going to go over this. It's basically the TDI's T47.1 declaration for use in existing surveys. I mean, it really just talks about it replacing or not replacing, but addition to the standard T47. T47 update, title company must provide a copy of the existing survey. Survey must be legible, must meet survey requirements. Now we're kind of just do a little overview here. Meet survey requirements and owner must provide sworn affidavit regarding any improvements. Just a reminder, I don't care about movable objects in the backyards, a shed on cinder blocks, on 2x4 sitting on the dirt. I don't care about it.
Barbecue pits.
Barbecue pits, I don't care about it. Above ground pool, I don't care about it. I'll bounce it back, the survey to you, and I'll say, hey, I looked at your pictures online in Google Earth. I can't tell if the shed in the backyard is permanent or not. It looked really good. It could be on cinder blocks. I can't see the foundation of it. I need you to put on the T47. But it is movable, it's temporary, I can move it around. Cool. Again, you're testing to that information. The seller is testing to that information. So don't push back if you have a title company that's questioning a movable object in the backyard. You have a chance to own your picture or Google Images. Questions to ask the seller when using a prior survey. Have you added any improvements to the property since you bought the home? I've had surveys where it's missing something, let's say a permanent shed that's in the backyard. It's not on the survey, but the seller said, well, this is the survey I got at closing. This is what I thought as the buyer. You're gonna need a survey. That's how the company shouldn't have closed on it because it shows something that's not on the survey. Well, now you're responsible for it. I've had sellers go back to the title company and have them pay for it. File a claim with it. So this is because they're using an existing survey and it's not on that survey.
So what about the drawing on the survey?
Again, you can do the drawing on it.
Okay.
You can do the drawing. Again, it's all to risk. I just always review risks.
What about a deck or a patio?
That's permanent on the house. Want it drawn or any survey? Unless you can go out there and pick up that deck and move it off the property, that's not movable, that is permanent. Did you change the boundary fencing? I've had agents, still agents, so this, I mean, seasoned agents, I'm talking over 10, 15 years. Maybe they moved the fence, they replaced the fence. It was old, raggedy, they put a brand new fence on there. I said, it was the fence on the boundary line? Did you remove the fence from the boundary line? And then you put a new one? Yes. Probably need a new survey. How do I know they put the survey of the fence where it was supposed to go? The brand new fence. Now you've changed the footprint of the survey. I'm probably going to need a new survey because I don't trust your seller and I don't trust contractors. I'm probably going to need a new survey. You messed with the fence on the boundary. Fences inside the yard, not that big of a deal. I also see houses that say you have a 10-foot easement in the backyard. I've seen people put like a little fence right on the 10-foot mark so they don't go past it, or they don't build past it. That's not a big deal. You're away from the setback line. It's not on the boundary line, and more than likely we're gonna. Did your neighbor add any improvements that you think might be encroaching on the property? That's happened. Did you sign any legal documents for any new easements? Conveyance of part of the property, utility dedications, or did you totally replat your property and change the legal description? Replatting the property changes your deed. Lot 1, block 2 was replatted to lot 99. Change the legal description. Is your survey copy legible? If it's too blurry, it looks good on your end, but you scan it and I can't read it, I'm not gonna read it. Take it out the stamp, the seal, signature, everything on every other on the phone. I can't read the degrees in the footage, I'm not gonna approve it. Is it signed and certified by the survey? Is any part of the prior survey cut off and missing? Like I told you, I'd get it when the seal is missing at the bottom. I want the full thing. If it's one of those gigantic surveys, the old school ones, do half of it. Scan this part, scan this part. All right, now I can put it together. Scan me 2 pages. That'll work. Is if the property is residential, improved, does it show any improvements, such as the house footprint? Did you add additional house or rooms to it? Did you put a mother-in-law suite in the backyard? Does the survey contain any language as follows? Slab survey, proposed improvement, preliminary, topographic. Topographic, that's a survey for stuff that's on the top, trees, shrubs, bushes, land stuff on there, natural stuff on there. It's not a boundary survey. Most surveys that you get don't just say boundary survey. They usually just say like survey or property survey. Sometimes they'll say boundary line survey. Topographic usually says it on topographic. So if you see it on dead giveaway, you see a preliminary survey, dead giveaway. You see a survey, it says survey done without the benefits of a title commitment. I get that a lot. Red flag, send it to me. Let me take a look at it. Which means the seller went and did his own survey without a title company involved, without a title commitment involved. I want to see. Is it actually even a survey? Or is it part of a subdivision plat? I talked about it earlier, or just a really good drawing. I've had surveys that were literally just drawings. And also, when in doubt, send it to me. Survey issues and underwriting considerations. This is what underwriting considers: the size of the encroachment, the nature of the encroachment, the age of the encroachment, an owner's policy versus a loan policy. Like I said, when there's a lender involved, they want specific endorsements for their policy. I need a survey. When it's just cash deal, owners, the only thing I care about is that survey coverage. That's the only thing. You don't get any other lender endorsement, no other endorsement. It's just that survey coverage for a cash deal. Okay? So this is what underwriting will look at. So if you have an issue on the survey and it's a cash deal, well, then there's no lender to push back. Our underwriters will review it. It's not too bad. We'll go ahead and we'll issue it. I'll make a little exception. We'll issue it. Such as this picture here. We have 2-story brick and frame. It's over a 25 EL, which is a building setback line. On an owner's policy, or underwriter will look at it and say, they're going to make an exception. Well, you'll never get coverage. If there's a house on the boundary line or even, you're never going to get full coverage. That just means we need to come and sue us immediately. We'll always make exceptions. But usually when there's a lender involved, they're stricter. They'll usually sometimes want a brand new survey. But if it's a cash deal, all right, I'll make my notation, the underwriting will approve. And then we're good. All the buyers okay with that. Encroachments of existing improvements, self-explanatory, frame garage, over a setback line and over the boundary line too. It's very simple. Just go and tear down part of the house. And you can see right on the top, it says 1.7 feet. So a lot of survey will show you the difference. It'll tell you the gap, what it is. So that's a really, really good survey. And survey review checklist. If you want to take a picture of this, I'm not going to go down every single one because I feel like I've talked about it. But this is just in general what we need when it comes to a really good survey that we will approve of.
Because I need a picture.
And sometimes you get a survey that someone mentions floodplain certification. You'll get surveys that don't quite look like a survey. It's missing an easement. It's missing setback lines. Survey should always have dotted lines running through the property. Easement or a setback line. But it kind of looks a little funky. It might be a flood certification, which means it's in a flood zone. You can send it to me. We'll take a look at it. All right, guys, that is it. Any questions?
Yeah, maybe after.
Sure.
I'll give you after.
Okay, perfect. Guys, are good? Good deal. All right, you are set. Thank you very much.
Very good.